Okay, it's a little past, sorry. It's a little past 1 o'clock, so we will get started. And so today, for what is hopefully our last RAC meeting, the plan is that we will, as a whole, we will go through the edits, the last red line that I had distributed earlier this week, Wednesday, of last week. Yes, I've lost track of what day it is, sorry. The red line, we'll go through the red line changes I've made. And then after that, we will have an opportunity for everyone to comment or whatever on the statement of need and fiscal impact. But then only those 13 members who were appointed by the commission at its special meeting, we will ask for them to vote on recommending the statement of need and fiscal impact. Before we do any of that, I would like to personally thank each of you. The whole Rules Advisory Committee process, I mean, all of you have given up a lot of your time, one Monday after another, to work on these rules with me. And I do think that having the input and guidance that you all provided has made them better rules. So really, I do want to say thank you to each and every one of you. I also wanted to personally make note of Jeb. I saw that in the newspaper. He was inducted or appointed to the Hall of Fame. So congratulations. Well deserved after all these years. And so anyway, does anyone have any other statements or comments before we jump into the edits?
Thank you.
You're welcome. Okay, well, Becky can share the red line. Scroll down to the definitions. So, and all I'm planning to do here is kind of talk about the specific red lines that I made. And so in rule numbers in 0005, sub 1 and sub 2, this was in response, and I can never remember who made the suggestions, but we got a couple suggestions from people about nonverbal communication, sign language, etc. So we added these red lines to indicate that communication and communicate included nonverbal means, transmission of information by nonverbal means, which would include sign language. The changes to subsection 4, are there any concerns about subsections 1 and 2? The changes to subsection 4. Oh, go ahead.
So, I mean, nonverbal, I get it if like somebody gives a thumbs up sign, that is a clear communication. I mean, facial expressions, I mean, someone with a bad poker face could find themselves with some complaints.
Yeah. I mean, that was the discussion that week, was on like body language and so forth. And I think it's really hard to say in a rule that would constitute community, you know. Oh, it's saying my connection's unstable.
Okay.
Sorry.
I'm a little uneasy about this, but I'll stop talking.
It isn't my intent that include all body language. I was trying to find a way to have it include sign language and gestures like the thumbs up, thumbs down.
Mhm.
I without making it more and more cumbersome, I don't know what I would change, but if you have suggestions, I would welcome that.
All right, I'll think about it.
Subsection 4. Oh, Matthew.
Yeah, did you say that it's not meant to include body language then?
I think it's too difficult for it to be body language. Like, how would the commission be able to regulate, the body language of, a city councilor in whatever city, Eugene, if they're just sitting there with their arms across their chest? Some people are going to take that as not being receptive to an idea and therefore communicating a rejection. But maybe they just have a stomach.
Yeah, no, I mean, I would agree with it. I'm just wondering then if it's saying that nonverbal means include sign language, do you want to have it say, but does not include body language?
Brenda Sanchez put in a comment saying nonverbal communication types are facial expressions, gestures, paralinguistics such as loudness or tone of voice, body language, proxemics or personal space, eye gaze, haptics, touch, appearance, artifacts, objects, and images.
Okay. I mean, yeah. Again, I think it's no, that's helpful, Brenda. I think some of those, like facial expression and body language, while I'm not disputing that they are a form of nonverbal communication, I don't know that they're a form we can regulate in these rules. I do think the gestures, the thumbs up or whatever, and sign language are easier to regulate. I will play with, we could say nonverbal means include, but are not limited to gestures, sign language, or gestures such as thumbs up, thumbs down, but would not include facial expressions and body language. I think it's just too difficult from an enforcement perspective. Joe.
I myself would just leave it as written. Includes but not limited to sign language, and actually leave that up to the courts to decide what nonverbal communication is.
Okay.
Hi, I'm in a Zoom meeting. Michelle?
Okay. So then in subsection 4, decision-making process, the red lines that I have here, we have slowly through the weeks been kind of narrowing the subparts here down to what actually is and in the decision-making process and trying to eliminate some redundancies. That is what these edits were for. So, one, under subsection D, weighing evidence, the use of the term evidence, I think, was inappropriate. One, because it's a sort of judicial term, and not all meetings and decision-making processes would involve evidence as much as they would involve information. And then choosing among alternatives is simply one example of a type of decision a governing body would make. And so we eliminated that and simply had the last section be making a decision. Any comments or questions on subsection 4? Joe? You still have your hand up?
I'm having upper lower hand problems right
Okay.
now. I'm a little
That's all right.
excited on point 5.
That's okay. Okay, under subsection 5, this was revising the definition of deliberate. We had a couple weeks ago long discussion about that the definition being the discussion or communication that occurs as part of a decision-making process caused problems, especially when we looked at the rule on what meetings are subject to the public meetings law, and that some of the discussions or communications, if we included this definition of deliberate, it caused problems for those exceptions that we have. So I think where we landed was simply to have deliberate means to engage in deliberations and leave it there and make it as simple as possible. Any comments or questions? Joe?
Over the last couple of weeks, I've been reading a few things, and the courts do not like a cyclical argument where you go back and cite a code because that's the violation, and you cite another code because that's the violation. To me, deliberation, it's not explaining the word deliberate. It's a cyclical argument, and I would think, a definition of weighing the facts and the arguments, and I would actually use discussions with a view to a choice or decision, carefully considering probable consequences, as well as advised or considered.
Right. The dilemma here is that deliberations is actually defined in the statute itself. And so the AG or DOJ counsel points out that for whatever reason, they want separate definitions for meet and meeting, for deliberate and deliberations. So we can't change the definition of deliberations. It's in the statute. And so deliberate simply is the process that when you engage in deliberations.
Well, could a code citation be put behind deliberation so people know where to go to? I mean, if I just picked this up and read it, it would be like, where does this come from?
Right.
Where is the guiding statute that explains this? I mean, I'm just being stupid here.
No, that's
if I
okay.
was Jane Q. Public.
Right. I mean, it is up above in subsection 3 that directs everyone to 192.610 for the definitions that came in the statute.
Okay.
Any other comments on subsection 5? Okay, subsection 6, discussion. Just changed a word. Just it's not question, it's a discussion of a matter. Maybe a question, may not be a question. So more stylistic than anything. Okay, and then subsection 9 on the quorum definition. It was just to simplify that. Sorry. This was just to use the word required rather than that must be present for the governing body. So it was trying to streamline it. And then finally, subsection 10. It was pointed out that discussions and communications, we didn't need both because the definition of communications included discussions, and the English professor in me said among instead of between. And then someone else pointed out the redundancy of saying writing or written. So this was all just cleaning it up. Joe?
The definition that you have in -0520, when you scroll further down, I think the two definitions should be the same. And considering that there are some organizations and entities across the state that actually don't have a means or emails, I would just put serial communications means a series of successive or sequential communications among members of the governing or public body using written paper, telephone, fax, or electronic means, including but not limited to emails, text, social media, or other electronic applications that communicates or conveys a given thought or position.
The dilemma is that this is defining something that's actually in the statute, not in the rules, and the statute uses the term serial electronic written communications. So this is providing a definition for the statute.
Okay. Sorry, I've been out of it for
That's
2
okay.
weeks, so I'm a little lost here.
That's okay. So, okay, so we will move on to 199-050-0010. And this is the governing bodies subject to the public meetings law. So the edits that we've made here, clarifying under advisory bodies that it's making their recommendations to a public body, not necessarily to another governing body. And so we made that edit in subsection 1B and subsection 2A. And then the majority of our edits here were in 2A and 2B. And this was, again, sort of after our discussions, not so much last week, but the week before, trying to, again, streamline this and eliminate any confusion that the rule might be causing. So the public meetings law does not apply to fact gathering bodies. Those are bodies that are limited with only the authority to gather and provide purely factual information to a public body, and that do not have the authority to make decisions or recommendations. So trying to, as clearly as possible, distinguish fact-gathering bodies that do not decide or recommend anything from those that do and would qualify under subsection 1. And then under the advisory bodies, made edits to better fit within what the law allows, which is an advisory body appointed by an individual public official that has the authority to make recommendations only to that public official, who then has the authority to act on those recommendations and isn't just a pass-through. And this is partly necessary because there are some bodies, I believe there are some legislative bodies that are appointed that would be governing bodies, even though they are appointed by an individual public official. So, and all that wrong, but Jeb.
Does section 1B establish that an advisory body to an individual public official is not a public body?
Under 2B, it is not a governing body.
It's not a governing body, but it seems to suggest that but that it's not a public body, which is just a committee or an advisory group is under the definition of a public body. Asking, for example, if we were to ask for a list of all public bodies within a governmental body, would they need to include advisory bodies to individual officials?
Well, the definition of public body in 192.610, sub 6, I think, includes all committees, etc. It's just that they may not be governing bodies. I don't think this is saying that they wouldn't be public bodies.
Okay, thank you.
It's just they're not, it's just saying that the public meetings law would not apply to them.
It just seems like an area of potential confusion because it's if a group that is formed to advise a individual official is not an advisory body under this definition.
It's advising individual public. It's a body that advises an individual public official. It's not subject to the public meetings law.
Right. Yes, as it would be under another, but this suggests that it's not actually an advisory body because the definition of an advisory body is limited to those making recommendations to public bodies. I don't want to belabor that. It just
I see where you're going, and I'm trying to figure if there is a solution there.
I don't have the answer. I didn't get
Yeah,
that
but
far.
it makes sense, and I'm just, yeah. Hold on. Okay. I'll work on it. Next up was Joe.
I think to probably address Jeb's concern between advising an individual public official, if the actual ORS was cited excluding this elected official or that elected official entity for creating, but I myself have a problem not with those elected officials that have that authority, but with all other entities where, in my mind, a fact gathering and an advisory body would, that consideration would still have to go through the city council or the board of supervisors for discussion, consensus, and then voting upon to allow the fact-finding body to do their job. And then if a particular elected official within those smaller entities was granted that authority, they would still fall under, a public vote. I mean, am I making sense to you, Jeff?
Whatever public body is making a decision or evaluating the facts gathered by this other non-governing body, the public body, the governing body that is evaluating the facts and reaching a decision or recommendation must do so in a public meeting.
Right, so it still falls under the public meeting law.
Right, because they would be either a decision-making or an advisory body. It's if you have a subcommittee that only gathers the facts, doesn't make a decision or recommendation, they are not subject to the public meetings law.
Yeah.
That's just it. In order for that body to be created, there has to be a vote of the governing body
Right, the
itself.
governing body is still subject.
So once that governing body, no, Scott, sorry. Once that governing body makes that decision, the public body per se would still have to post notices and that sort of thing, wouldn't they?
I don't think so, but I'm
Okay.
sorry. Go ahead.
Okay, no, that's fine. Like I said, I've been out of it for 2 weeks, and I know, Scott, you have. I'll defer to Scott now because I know he has far more experience in this than what I do.
Okay, so next up is Matthew.
I'll let Scott go ahead first.
Okay, all right. Well, Jeb, we're going to skip over you and go to Scott because
That's absolutely.
we'll come back to you.
Absolutely.
So it does not necessarily take a vote of a public body to form a committee that this
Yeah.
rule would cover. And so the example I think I used when this was originally discussed is we have a conflict in a park system related to pickleball versus tennis players. They don't like each other, and or at least they don't agree on stuff. The public works director forms a group on his own, has the authority. He just pulls a group together to say, you're going to advise me on how we're going to schedule and resolve this conflict. That's who we're talking about. This is largely, if this is largely about being advisory to staff for their functions. This noticing the pickleball tennis committee, I don't know what that adds to this conversation. If you wanted to be very clear, you could simply say, instead of public official, it could be advisory to non-elected agency staff. If there was a concern, none of the bodies we're talking about have the authority to do anything other than act as a sounding board to a department head or a staff member. So
Scott,
Yeah,
it's a lot,
the
this is a
pro-
lot of this would really tie our hands in like developing I mean, simple sounding board committees and groups that don't advise the city council. They just say, let the let the Parks Department or a Public Works Department talk about,
Mhm.
where's the bike sensor gonna go? How are we gonna resolve what goes in a pollinator garden? I mean, it's this,
Yes, and the only reason that we have public official instead of like limiting it to staff or so forth is we needed it to be broad enough to address what's in the AG manual in terms of like the governor and so forth. So that's why we left it that way. So now we'll go back. Matthew.
So I just had a couple comments here for under subsection 2. The public meetings law does not apply to the following types of bodies. One, missing a colon there at the end. But should that be following types of public bodies or governing bodies?
Well, we don't want to say that they're governing bodies
Okay.
because
So then
if they're
should,
governing bodies, they're gonna be subject. Yeah,
okay, so it would just be the following types of bodies, and there's no
fact
distinction of.
gathering. I think so, but I do notice that my parallelism in A, B, and C isn't quite there. So I'll fact gathering bodies, advising bodies that advise individual public officials and certain multi-jurisdiction bodies.
Okay. Yeah, and that was just gonna then line up with the next thing I had was just under 1, you got them with decision-making bodies, then a decision-making body is, and you
Yeah.
didn't have that same type of structure under 2. But
Yeah.
okay.
I will add the colon and improve the structure and think about whether in the lead in onto whether I want to specify or qualify the word bodies. Jeb.
I guess I am more interested in the existence of some of these bodies than with their powers. I understand that bodies advisory only to a specific official are not bound by the meetings law, and they are not governing bodies. But in my mind, they are public bodies. They do exist. For example, if the planning director had an ongoing advisory body made up of 5 real estate agents and they met every Wednesday, I'd want to know that that body existed and was advising. I would understand that they're not bound by the public meetings law, but it's the existence. So I'm wondering if under advisory bodies, if it weren't a definition, but it's an advisory body with authority to make recommendations. So the law applies to advisory bodies with the authority to make recommendations to a public body. Therefore, it doesn't apply to advisory bodies that only make recommendations to a particular official. But in the way it's written, it seems to limit the definition of what an advisory body is unnecessarily.
Okay, so right now it says an advisory body is a body with the authority to make recommendations to a public body. And then under 2B, an advisory body appointed by an individual public official with the authority to only make recommendations to that public official would not be subject to the public meetings law.
Understood, but one is an advisory body, the other is a fact-gathering body. They're not, they're different.
Well,
Names
no,
of the
because the second would still be an advisory body. It's just not one that, because they are only making recommendations to the individual, they're not subject.
Okay,
So
yeah, yeah,
I think both are advisory bodies. It's just sort of which is subject to public meetings law or not. I think to get to your point about the difficulty of even finding out what bodies are in existence, that I think is more of a matter of public records law than public meetings law. In terms of public bodies really not sharing and not divulging the creation of all their various subcommittees and so forth.
yeah, I can.
So I'm not sure I can solve that problem.
I understood. Yeah, thank you, Susan.
Okay, we will move on to subsection to Rule 15. We didn't have a lot of changes. We had some under subsection 4. And this was again to streamline the language a little bit and eliminate some redundancy. So just saying, reiterating that a private meeting where a quorum engages in discussions or communications that are part of a decision-making process on matters within the authority of the governing body would violate the public meetings law. This was just sort of clean up Susan's wordiness. Any comments or questions? Okay, the next edit is in the rule for 0040. Okay, so. Start with, we talked about notice, and last week or the week before, some people pointed out that they don't put notice on their own website. They use a third-party hosted website, or they link to the notice. So this was just an effort to incorporate that possibility. So provide notice on the public bodies or the governing body's website or on a publicly accessible website hosted by a third party that has a link. And then, as before, to address those governing bodies that may not have any websites, if they don't maintain a website, you can satisfy the notice requirements in any of these alternative methods. I incorporated the transparency website. So, any comments or thoughts about the revisions to subsection 2A? Matthew.
So is that to mean if a governing body, well, the public body does have a website, then they can't satisfy the notice means through a bulletin board or newspaper notice? That it's only for a governing body or public body that doesn't have a website can do that?
I mean, I think as it currently is written, yes. Now, what I would want to hear from you is why would and I'm of course remembering back in the day when all notices were, posted in some official location, a bulletin board, the window of the door, the neighborhood grocery store, as well as in the newspaper. If a governing body has a website, I guess I'd want to hear from some of you, why would they not post their notices to the website? I mean, what would the objection be?
I mean, I just don't see necessarily limiting their ability to post a notice somewhere. And requiring them to do it on their website, which, I mean, if they have the website, like, it's probably going to be the most efficient place and appropriate place for them to do it. But I was just wondering why that would limit them to only doing it there.
Oh, I don't think it's saying they must only do it there. I guess my thought was that your question was, if they have a website, can they choose not to post to the website and just post to a bulletin board somewhere? Or like, there's no requirement here that would prevent a governing body from posting to multiple locations. Now, I will say, based on certain cases we've seen, if they have multiple different locations, that's fine, but it's important that they all actually have the same notice posted with the same meeting location. So, Rob.
So I think I read maybe the language differently than Matthew was reading it. I read it somewhat similar to you, Susan. I think what 2A is saying, at least to me, the way it reads, a governing body satisfies the public notice requirement. This is one way to satisfy it, and this rule basically says if you do this, you're essentially deemed satisfied. I don't think this is the exclusive method to satisfy the requirement in statute, which is kind of parroted up in subsection 1. So I'm actually fine with this language because I don't think it's a requirement. I think it basically says if you do this, you're good.
Yes. Does that help, Matthew?
Yeah, I understand that. And I was just trying to think of if there was a situation where maybe the governing body meant to post something and publish a notice on its website. It also did it on a bulletin board. And if the notice of the website was incorrect for some reason, but the one on the bulletin board was correct, would that satisfy the notice requirement?
That kind of gets to what the prior case, which is, it makes me long for those days when governing bodies basically had to adopt a rule or whatever, saying, here is where our official notices will be. Like they used to adopt what newspaper they're going to publish in. Just because if the notices are not the same, if they are posting notices to multiple locations, and the notices, the example from a recent case was this group published a notice on Facebook, they published a notice on a bulletin board and somewhere else in a newsletter, and each of them identified a meeting, but each identified a different meeting location. And so, depending on what notice you got, you might show up at a wherever and find the meeting was there or it was not. And the commission held that the notice did not satisfy the requirements because it didn't provide the public with actual notice of where the meeting was being held because they had too many conflicting notices. I mean, I think that's the danger of having notices posted in different locations. Joe,
On your fourth line, where you start with website, and then you have underscore or on, I would prefer to see and or. Because
they're not going to let me do and or.
they're not,
No, the
because the
writer's
problem-
handbook people.
the problem that I see with this, and I've seen this in another state, where if it was a highly contentious issue, they would post it on a third-party website and not on their actual website, so it would reduce the public outcry and or public support. So,
Right.
you know, that would be
That
one
is why I added the link to the public body. So even if you're posting it on a third-party website, you would still have to link it from your own website. Meaning anyone going to your own website would find the link to look at this notice that's being hosted on a third-party website.
Okay, I understand what you're explaining there, and I do agree with that, but it's the or statement.
Mhm.
You know, if you post it on the third-party website, you don't have to post it on your governing body website. But you still comply. It goes back to the same issue that, if I'm not mistaken, what Matthew was raising.
Mhm.
The either or. If you do it here, you're in compliance, but if you do it there, you're also in compliance. And I'm just trying to stop spurious chicanery.
Well, I can't
Sorry.
change the or to an and because that would require people to post to this third-party website, and that's not a requirement. And I can't, under the rules guiding rule writing, turn it into an and slash or. They won't allow me to do that. So I think what we have is simply saying you must satisfy the notice requirement in one of these ways.
Okay.
Rob?
Sorry, you covered what I was going to say. Thanks.
Okay. Okay, the next part of 040 is down in 2B sub C. And this was just people reminding me to make sure that when we talk about actual notice, it's adding the reasonably calculated language. And then under the media notice, eliminating the by any other means reasonably calculated, those means do not have to be calculated by the governing body. So. Questions, comments on that? Okay. Move down to 3 subsection D. My least popular rule. Executive session, well, no, it's a different rule that's less popular. The executive session notice, just a reminder that under subsection 3DA, that if you're noticing a standalone executive session, the notice has to meet the notice requirements, and then also specifically has to identify the specific statutory citation and the subsection and paragraph. Like, say we are going to hold an executive session under ORS 192-660-2E2. Consult with our designee for the on negotiations for a real property transaction. Where are you going?
Oh, I was trying to find the actual, never mind.
Sorry about that, everyone. So, and then under subsection B, if it's in a regular, special, or emergency meeting, that you have to still, the notice still needs to satisfy the notice requirements, and you can identify in an open session, make an announcement of the specific statutory provision, subsection, etc., and a description of that statutory, of the topic to be discussed. And then can you scroll down a little? And that announcement has to be in the public session of the meeting. Jeb.
I really don't even want to raise this, but if that has to be done in the public portion of the meeting and it is being attended by media via online, I assume that means that the body would then have to require that media to turn off their access when they went into executive session.
I'm not sure I follow you.
Well,
I mean, this has nothing to do with sort of the access. This is just how the governing body is giving notice of the executive session.
okay. Oh, and so if they're having an executive session only, they don't have to make that announcement
No, because it's all done in the notice.
because it's already been noticed. Okay, all right. As long as I'm here, I'm going to just skip ahead because a lot of the next part doesn't have any changes. But I wanted to ask a question about the 48-hour notice on notice of a regular meeting, which is not part of the ORS, but a part of this rule. Wondering whether you've had any experience with bodies that regularly add important issues to the agenda. We've had a little bit of that where it's almost like not giving notice when if you're required to give 48 hours notice of a meeting and you do that and then you add or take away important matters 24 hours before that meeting, there's no notice requirement for that. Yeah. And I'm not trying to eliminate that power to add to the agenda, but I'm wondering whether there's any experience with sort of serial violations of the spirit of the law.
I don't know that we have had, I mean, since our enforcement is only 6 months old, about a little over 6 months at this point, I don't think we have the case law here or to establish a precedent for that. I think it is the dilemma, of course, is that the law itself allows for changing your agenda and up until the very last minute. So we can't fix that. I think, frankly, I think the best, I don't know what the commission would do if we got complaints about a group that repeatedly engages in that sort of activity. But I think the best solution to that sort of activity is transparency, is calling them out on it and bringing it to light. So whether that's done through, an advice or an opinion, or the commission taking it up at some point in a complaint, I don't know.
I'd agree with that. Thank you, Susan.
Joe.
I would like to just spin off a little bit on the 48 hours. Does that 48 hours include weekends, or is that 48 hours per business according to a business day calculation?
It's 48 hours, period. It's not saying, business days would be, if it were business days, it would say business days. It is literally 48 hours.
So a meeting that would be held on Monday, they could issue their agenda on Friday.
That
And
is
that would
correct.
still constitute 48 hours.
Correct.
And then the second part to address Jeb's issue of adding and subtracting, the safest bet would be to proceed with the existing agenda, because if things are added and dropped off, it's not actually giving notice of what's occurring in the meeting. You wait till the actual meeting and say, we are removing this particular agenda item to a future meeting. That would be the cleanest way to do it, and in my mind, the safest way, ethically speaking, but
Yes.
I know not to have ethics.
But as I said, the statute itself gives them the authority to change the agenda beyond, even after the notice has been issued. Scroll down. This gets to the hour thing. So under subsection 4C big A, these were just cleaning up the language on the emergency notice to make it align better with the statute. So for an emergency meeting, the governing body must, in the minutes, describe the actual emergency and the reason why the meeting could not be delayed to allow at least 24-hour notice. I then in sub B added the reasonably calculated language. And then in sub C added the sort of third-party hosted website language. So basically, if it's an emergency, you give as much notice as you can. And you must make a record of why you couldn't give 24-hour notice. Any other comments on this rule? Okay, we'll skip ahead to 0050. Oh, let me scroll back up. It went so fast. Oh, there was. I deleted a comment. Okay, I didn't get it. Okay. Oh, this was some rearranging, and this was, as Robert pointed out, the whole the governing body shall, to the extent reasonably possible language. I had incorporated that beyond what the statute actually used. So what I've done is taken what used to be 3 subsection A, B, and C and broken it into 3 different sections. So what is now subsection 2 used to be subsection 3B, which is for meetings held by telephone or communications, you have to make a space available for people to listen in real or view in real time. Then what is now subsection 3 used to be subsection 3A. the governing body shall, to the extent reasonably possible, provide members of the public an opportunity to attend by telephone, video, or other electronic means, and added the exclusion for exec sessions. And then subsection 4 is the media attending executive sessions paragraph. So let's talk about subsections 2 and 3, and then we'll jump into 4. Any comments on subsections 2 and 3? So we will get into 4, which is, I'm sure, what Scott and many others have comments on. The changes I've made for this, obviously I specified executive sessions where the media are statutorily authorized to be present so as to eliminate those executive sessions where they're not allowed in. And then I added this comment from Matthew that will help. I may have missed a reasonably calculated. So thank you, Matthew. So Scott, I added at the end of subsection 4 that nothing in this subsection prevents the governing body from establishing reasonable security measures to ensure attendance is conducted through a secure connection or method. I know that doesn't necessarily may not necessarily get you to where you want to be on this, and I understand that. It was, yeah. Well, I'll let you go.
So I find the phrasing interesting. Well, thank you for the attempt on here. Nothing in this subsection prevents. I have absolutely no idea what those security measures would be that would allow us to know definitively who was on the other end of that Zoom or virtual connection. I'm not a tech person, so maybe there's something I don't know about, but I don't know what it is. I think what this does is it essentially allows us to have an executive session, but you've prevented us from closing the door. As long as if we don't know who is on that other line, we don't believe we're required to allow that sort of attendance. And I find the phrasing interesting because it's where the media is statutorily authorized to be present. And so virtual is not present. We believe that the rule, also, the legislature was presented with a bill to do just that, and they intentionally rejected it. It wasn't just the bill died because of lack of calendar. I know there's not a lot of legislative record because of the way it got lobbied in the short, but I think it was short and long session. But they chose not to do this. And I don't think the OGEC, you can accomplish the rulemaking what the legislature elected not to do. And for my members and the counties who are home rule entities, there is nothing in the statute that preempts us from creating additional requirements or even defining media or defining what attendance means in that statute. And the Supreme Court has been very clear is that home rule is a constitutional protection. And if the legislature wants to foreclose that, it has to do so clearly and unambiguously. That's not what the statute contains. I will also say we will be a hard no on final passage of the rules, both in the RAC and at the committee with this language in there. It does boggle the mind that this remains in the statute given the clear legislative history and our legal authority.
Okay. Rob.
Probably no surprise. I just want to be associated with Scott's comments. I think this exceeds the power of OGEC to enact, and I think the legislative history provides exactly what Scott described. And I think you're stepping on home rule powers here. And you know, on behalf of the county lawyers, we just can't agree with this.
Please.
I'm going to echo Scott and Rob's comments that I don't see any authority for this rule. And I agree with Scott that, you know, that I don't know that there are many security measures, reasonable security measures, other than requiring physical presence that could necessarily accomplish this. I'm not saying they aren't out there, but to me, the physical presence requirement is a reasonable security measure.
Jeb.
Okay. Yeah, first off, I'd like to suggest we go into executive session and never reveal anything that's said here from now on. But given that we aren't going to be able to do that, I'm going to take off my ONPA hat, and I'll just comment as publisher of the News Register in McMinnville. We've gone to executive sessions for a long time, and I don't know that we've ever gone to one by digital media or not, but sort of given where the county and the cities, and I assume the school districts and eventually the special districts and anybody else will be on this, it's hard for me to fathom having to spend a whole legislative session riding back and forth to Salem to talk about this issue. So it's sort of a mixed bag within ONPA. I think that there are I know that there's some who really care about this and think it's very important, and there are many who really don't. I hope there's some consideration given to whether or not it's worth the legislative battle that could ultimately damage the whole Oregon executive session law potentially, if in given the importance that it's played in good government over many decades. So that's my News Register comment, not my ONPA comment.
Okay. Any other comments? Okay. That brings us to
Excuse me.
199-050-0055.
Excuse me, Susan.
Oh, yeah, Joe.
Thought my hand, like I said, I'm having up-down hand problems today.
Yeah.
I do agree with Scott and Rob and and Jeb, and I'm going to push the envelope on the home rule section. And this is just based upon various observation in court systems. The first thing that they mandate that you do is some courts have you leave your cell phones at the door. Some require you to turn off all recorded devices. They do not allow recording, even if there are Zoom links. The second thing that I would actually push for is that based upon the at present or being present notation, that if the governing body is going into executive session virtually, then the governing body, in my mind, should make available in their meeting chambers a single laptop via Zoom with a staff member present. I would take out this any person. If any person, including any member of the governing body, I would take out that any person in the governing body, because that means if one person of that governing body attends by video, Zoom, whatever, then you're allowing a breach of security in that aspects. And if you're trying, if you want to stop the breach of security, you make physical presence. You have them turn off their cell phones, any recording devices. Go back to old school. And I know, Jeb, you're not happy with that. But, you know, we've had 100 and 200 years of handwritten testimony. Why should we flip the light switch and allow for something that creates a breach of security? I don't know. That's just me being cantankerous today. That's all.
Okay. Any other comments on 50? All right, we'll move on to 55. This was the edits on 55 were one, a rearranging because it made more sense to talk about the votes versus the ballots. So reversing subsections 2 and 3. And then remind me on subsection 55, subsection 1 to delete or. So all official actions shall be taken by public vote. And then what is now subsection 2, the only edit there was changing governing bodies to public bodies with more than 25 members, because that is the language in the statute. And then subsection 3 is the secret ballots are prohibited. Subsection 4, I did go back to the statute and the AG manual and did confirm that if you're using a written ballot, you are required to announce the vote by each governing body member's name. Rob.
But just for the record, I read the AG's manual and the AG's opinion upon it, which it relies, which is a 77 or 79 opinion, differently than you do. I believe that the AG's manual and the opinion require that the vote be placed on the record, essentially the vote results, not the actual vote of each individual member. It may be nitpicky, but I just want it to be of record. It doesn't affect my client, but it affects a former client.
Any other comments on 55? Okay. All right, let's take a 5-minute. Oh, Jeff.
Oh, there's just an extra word not crossed off, I think, on sub 1.
Yeah, I caught
Okay,
that. I
you
caught
saw
that.
that.
So
Okay.
I made
All right.
myself a note to delete the or.
Yeah, okay, thanks.
Thank you. All right, why don't we take about an 12, 13-minute break. Let's come back at 2:30 and we will finish these up. Okay? Okay, well, welcome back, everyone. Just hold on, we're just getting our document back up. And we are on 0070. Okay. Okay, everyone, so let's get started again. We are now on 199-050-0070. And sub 1, just cleaning up the, a violation by a governing body. It didn't need members. And then scroll down to sub 3. Okay, so this is all on the grievance process. And so I was trying to, based on our conversation a couple weeks ago, to address that, the public body can accept in-person delivery, but let's put some parameters around that. So no delivering it in the middle of the night or in the grocery store. That the public body can specify that in-person delivery during regular business hours, as well as by mail, email, and then added in addition, the public body may accept grievances by other means it deems appropriate. Specified that if the public body, those that can, post on the website the contact information and then identify the regular business hours during which in-person delivery can be accepted. Cleaned up the language of chief administrator to chief administrative officer. Hopefully that can incorporate all potential heads of organizations or public bodies. So any thoughts or comments on the revisions to subsection 3? Gabe.
Yeah, I just want to thank you for adding in the time, place constraints. I think that this addresses the concerns that the OAMR had about getting them during off hours. So I appreciate that. Thank you.
Oh, absolutely. This is absolutely sort of what is intended to be accomplished with the wrap like this, is to get those perspectives. I think it makes it better. So thank you. Joe.
Would that also include serving a grievance in a publicly noticed meeting?
Well, it's up to the public body to say, that this is who we will have you provide grievances to. I mean, I don't think it's a very good idea to serve a grievance during a publicly noticed meeting, because, I mean, the public officials would be otherwise occupied at the time. But
Well, to me, it would be a form of transparency for the public. Instead of behind what I would call closed doors by serving during regular business hours, technically a city council meeting or a governing body meeting itself is a regular business hour operation. But
that is true, but there is no requirement that they allow public comment in a public meeting. So and given that the grievance has to be in writing, it shouldn't make any difference if it is delivered or handed to whoever the designee is. I mean, if the designee, if the person is the chief administrative officer, or it may not be someone on the governing body, so doing it during the public meeting doesn't necessarily make a lot of sense. I understand the transparency thing, but you're not reading it aloud. This is a written document.
No, I'm not saying reading it aloud. I'm just saying you're being served, a grievance complaint and dropping it off in a public meeting, not articulating the contents. It'd be like no different than Jane Q. Public saying, well, I don't agree with you chopping down the cherry tree in front of the library. That would be a public comment.
That's true. All right. Gabe.
Yeah, I just wanted to say that as the person who would likely be a designee to receive these things, based off of reading it and my interpretation of the rules as written, I would not accept them during public meetings because, like Susan rightly said, we don't have to take public comment. And I'm doing my job taking minutes for the for the council meeting during the meeting, and any time before and after the meeting are technically not regular business hours. If your meeting starts at 6 p.m., right before and right after are not your 8 to 5. So I would recommend mailing it in or submitting it during regular business hours as written. So yeah, I don't see meetings as the way to go for this. You can definitely, if you have public comment, take your time during a meeting to say that you have a grievance with the city and that you've filed it, et cetera, et cetera. But I don't see that as the way to accept it in a business-like fashion. So thank you, Susan.
Yeah. Jeb.
I'm wondering if it's clear what public body you're filing your grievance with. If the grievance is a subcommittee of the Planning Commission, which is a public body, is it understood and a given that you would file your grievance with the city or the county or the topmost public body in the string of public bodies? Or would you file a grievance with the most immediate public body that the governing body is reporting to?
This goes back to my hatred of the definition of public body. I think a good question, Jeb. I mean, the statute just says public body. It doesn't say the specific governing body within the public body. Let me look at that.
So statute might need clarification, I suppose.
Oh, trust me, I
okay.
don't disagree that the statute needs clarification.
Yeah.
Matthew.
Well, I think my point was also probably going to go to the statute needing clarification. But if you've got the written grievance shall be submitted to the public body within 30 calendar days from the date of the meeting where the alleged violation occurred. And
yes.
So then the statute's within 30 days of the alleged violation. So is that for the purpose of this, I guess, statute, is the only violation for this grievance is the result of a meeting? So, it talks 610 to 705, which includes things that are outside of meetings.
Yeah.
So, and if you have, like, for example, if just there's minutes haven't been prepared,
Right.
where's the grievance period for that? When's the start date? Again, so my concerns are more from the statute itself, not necessarily the way that these rules are drafted.
So well, many concerns about the statute, but I think to make the rule better accord with the statute, I think I need to amend subsection 2 and have it from the date of the alleged violation. And get rid of the meeting language. Because I agree, I think the statute specifically just says the date of the violation, which then would include all of the potential violations that would not necessarily take place in a meeting. Matthew. Oh, Gabe, sorry.
No worries. I just want to say I really like Jeb's question about who receives the notices. It does, by my interpretation, the fact that it says chair of the governing body would mean, in my case as a city, the mayor, and not the chair of, for instance, the Arts Commission, which is where, let's just say there's a grievance of the Arts Commission didn't meet at the right time. But since it says chair of the governing body, I interpret that as the mayor and not the chair of the Arts Commission. But I agree that there should be some clarification there, because I don't want the chair of the Arts Commission to receive a thing and not know to tell us that
Right.
not know to tell us that they received a complaint, an official grievance. So yeah.
Right.
Thank you, Jeb.
And that was kind of the intent of having the bodies designate, so that you don't get a utility worker somehow accepting a grievance and putting it in his pocket and forgetting about it. So, yeah. Courtney.
Well, and not to belabor the point, but under subsection 2A, where it says you need to identify the governing body that allegedly violated the meetings law, does that mean that a public body can't? I'm getting caught up in the use of governing body versus public body. I guess I'll just leave it there.
As do I frequently. So it is only governing bodies that are responsible for violations of public meetings law, members of governing bodies. So, which is why back in the beginning, we spent all that time defining who counts as a governing body and who does not, subject to public meetings law. So where it says the grievance needs to say, so the grievance submitted to Gabe would be, okay, this city, and so it's the city's budget committee that someone's saying that they would submit it to Gabe, but the grievance needs to identify what advisory committee, the budget committee, and what date, and so forth. So that's what the intent of 2A there is, to identify which governing body within that public body engaged in the violation.
If that's the case, then section 3, then it seems to me should say the governing body shall accept grievances.
Logically, that makes sense. I'm not sure that's what the statute is in terms of, I think the statute says public body. And so that doesn't help this, because I think if we all get mixed up between the public body and between public body and governing body in the context of these rules, I'm well aware that means that other people reading them are equally going to get confused. But under 3, the statute says public body, so I have to allow it. I have to say that the grievance can be submitted to the public body. And arguably, you kind of don't want the grievance necessarily to go to the governing body. I mean, there may be some governing bodies that will designate themselves to be the person that the grievance goes to, the chair of the governing body. But in most agencies and public bodies and cities and school boards, I think it makes more sense that it would be someone like Gabe or the chief administrative officer, the city manager, whatever, as being the designee, because governing body members who are volunteers, may not understand all the processes in terms of how to handle a grievance. I think in most cases, you want it to be someone who is familiar enough with the grievance and response process. Jeb.
It seems to me it could make sense that the public body is the public body first above the governing body, because I'm talking about a committee of the planning commission that you're grieving. It seems like it could make sense that you would file your grievance with the public body, i.e. the planning commission, that governing body is a governing body of that public body. And then, this could go down to committee, subcommittee, subcommittee, but I guess you just have to do one or the other to accept that it is the top governing body of the entire governmental entity that is going to take these grievances, no matter where the governing body being aggrieved lies.
I agree. It can be a bit of a rabbit hole. Joe.
If you cite ORS 174.108,
That doesn't work.
Yeah.
It doesn't. That's a great definition of public body, but that's not the definition in 192.610.
Well,
I wish it was.
It appears there's a failure of communication and being on the same page.
Possibly. You're expecting
Did I say that?
Our statute.
Oh no.
I mean, nothing like convolution. Sorry.
No, that's a valid point. Okay, any other comments on 070? Oh, 075. This was my staff laughs at this one. Someone pointed out at the last meeting or the meeting before that I had used passive voice, which, given that I was an English professor that used to slap my students for using passive voice, is funny. So I made it a more active voice. That was it. 0080. The only edit was to subsection 4B. And this was simply to cross-reference to the statute that defines governing bodies of state government. And then 0085. Oh, Joe, you had a comment on that?
Yeah. Under the exceptions on 0080.
Yeah.
To me, that seems to create an inconsistent stricture of compliance. I mean, what's the difference between a governing body that has less than $1 million and one that has more than $1 million when both spend taxpayer dollars? I mean, to me, it seems if it's sauce for the sauce for the goose, it's feed for the gander.
I
They should-
understand
should
that, but the
be-
statute is the one that sets the mandatory training threshold of $1 million expenditure. So the statute says only a governing body, members of a governing body of a public body that have annual expenditures of $1 million or more are required to take the mandatory training. Others are encouraged to do so.
Well,
Everyone is encouraged to do so.
that definitely needs to be relooked at. I'm sorry. That just needs to be relooked at.
Um, okay, any other comments on, we were in 85? Okay, and 85 was just a little clarification since executive director wasn't a defined term anywhere, so specifying that the commission will delegate to me to do the training review so that it happens. Okay. Any comments on that? All right, we'll move on to the amended rule, which is 040-0027. And basically, I went through, the first part has the addition in sub 1. So subsections 2, 3, and 4, I took what we previously had and tried to streamline and clarify it. So I rearranged it. So we start with employees and staff members, then move to public officers, and then move to chief executive officer. The one additional rule, which isn't in here, but someone pointed out last time, is under 4A. It currently says satisfy the requirements in subsections 2A and B and 3A and B. That should just say 3B because obviously 3A is 2A and B. So 4A should say satisfy the requirements in subsections 2A and B and 3B of this section. Any thoughts or comments on the revisions to the amendments to 0027? Okay. And in 0015, 199-008-0015. So this was changing the penalty matrix and then tables A and B. So the only change to 0015 was adding in public meetings law, and then table A and B. The first change was in the header. Someone pointed out last time that 171 and 192 were not precise, so I specified the actual statutes within our jurisdiction. And then, as I explained last time when we spoke, under advice sought and followed prior to violation, which is about 2/3 of the way down, We are proposing to delete the 5-credit deduction for OGEC advice. As Scott said, that doesn't make a lot of sense given that the advice statutes in Chapter 244 specify that they're safe harbor statutes so that you would not get a penalty, you would get a letter of education. And then adding the final row, which is action to prevent future violations and obtaining training to allow an additional deduction for those people who have, even after a complaint has been received, made an effort to obtain some training and taken actions that would prevent future violations. Thoughts or comments on the matrix?
Thank you. I apologize for the thumbs up. I forgot we had that whole conversation about nonverbal communication. Thank you for making that change.
Yeah. And that is the end of the rules. So, long haul. All right, I will be going through my notes from today. Becky is looking, questioning.
Yeah, why don't we say sanction letter of education? Because that's what we issue. We have the authority to do reprimand or correction, but more often than not, we do a letter of education. Shouldn't we add letter of education
Where?
on table B?
Oh, letter of reprimand or correction. Yes, we should. Okay, so here is the proposed final edit here on table. Well, if we're changing table on table B, the first line where it says 2 points or less, it says the sanction would be a letter of reprimand or correction. I'm going to add in a letter of education, comma, reprimand or correction. Something along those lines. Matthew put in the chat letter of reprimand, explanation, or education. So I'll look at our statutes and decide what they call them. But yes, the vast majority of people are going to get a letter of education. I have done a letter of reprimand to someone who, I don't know why we decided it had to be a reprimand, but we would prefer it to be educational. Joe.
My question really doesn't have anything to do with what was discussed today, but from the first 2 meetings.
Okay.
Are the public meeting laws going to incorporate the sovereignty of the tribal nations?
I don't believe we have that authority. I mean, to the extent that.
Well, I mean, I don't mean
recognize-
regulation. I don't mean regulation. I mean just defer to their governance on that.
I think other laws already accomplish that we have no authority in the rules to address that.
Okay. I was just wondering because I do support their sovereignty.
Absolutely.
And I do feel, yeah, I mean, I read the Trail of Tears and that one really just, yeah.
Any others? Okay, so it is 3 o'clock and the final order of business is that to review the statement of need and fiscal impact, and then the 13 people who were specifically appointed by the commission itself will need to vote to recommend the statement of need and impact. This isn't a vote on the rules. This is simply to recommend to the commission the statement of need and fiscal impact. So you were sent the statement of need and fiscal impact earlier last week. So, and I don't believe I need to read it all aloud. Hope not. Have you? Well, to be safe, we might as well read it aloud. Casey wants to read. Casey's like, no.
Want me to read that?
There you go. Casey will read the statement of need and fiscal impact.
Statement of need and fiscal impact. Need for rules. The rules in Division 50 are needed to provide guidance and clarification regarding the requirements in Oregon Public Meetings Law, ORS 192.610 to 192.705. 199-040-0060 was added to clarify the prohibition on making final decisions in executive session. 199-040-0027 was amended to clarify the procedures required by ORS 192.6607D before holding an executive session under ORS 192.6602A. 199-008-0015 was amended to update the Commission's penalty matrix. Documents relied upon and where they are available. Number 1, ORS 192.610 to 192.705, and I will spare you me reading the link. Number 2, the Attorney General's Public Records and Meetings Manual 2019. Statement identifying how adoption of rules will affect racial equity in this state. Accessible information in plain language. The administrative rules seek to provide information in a clear, understandable manner so that the public meetings law is more easily understood by public officials and community members. By making content more accessible, barriers that have historically disadvantaged marginalized communities are reduced. Transparency for the public. Governmental processes that lack transparency create a disconnect between public bodies and the people they serve, particularly minority groups. The new and updated administrative rules promote transparency by clarifying how public bodies can and should provide detailed and easily accessible information about government processes. This allows all members of the public to see and understand how decisions are made, promoting trust and accountability. Representation. The administrative rules uphold the importance of representation, so that community members, including those from underrepresented racial and ethnic groups, have an opportunity to participate in the governance process. The new and amended rules include provisions for ensuring public notices and public attendance or access to meetings. Fiscal and economic impact. The new and amended rules clarify laws that may have fiscal and economic impacts, which could include increased costs for public bodies incurred to comply with the requirements of public meetings law. The economic impact of compliance with these rules, positive or negative, on state agencies, units of local government, tribal governments, or special interest groups arises from the statutes themselves. Statement of cost of compliance. Number 1, identify any state agencies, units of local government, and members of the public likely to be economically affected by the rules. Generally, the rules themselves do not create any additional cost beyond what the laws already require. OAR 199-050-0085 may have an economic impact on organizations seeking commission approval of their training programs, as it establishes requirements for annual submittal and review of the organization's training programs. The cost of compliance with this rule is minimal, consisting primarily of staff time for the organization. Number 2, effect on small businesses. Letter A, estimate the number and type of small businesses subject to the rules, none. Describe the expected reporting, record keeping, and administrative activities and cost required to comply with the rules. None. Letter C, estimate the cost of professional services, equipment, supplies, labor, and increased administration required to comply with the rules? None. Describe how small businesses were involved in the development of these rules? No small businesses were involved.
Okay, so that is the statement of need and fiscal impact. Does anyone have any questions or comments? Rob?
I would just propose one minor change if you'd be willing to consider it. On the bottom of page 1, in statement of costs of compliance, in subsection 1, the non-bolded language currently reads, generally, comma, the rules themselves do not create any additional costs beyond what the laws already require. I would urge you to strike the 2 words do not and substitute the words are not intended to. So it would read, generally, the rules themselves are not intended to create any additional costs beyond what the laws already require. I think that's more accurate and more than happy to explain why I think that's important if you'd like.
I guess my question is, I don't necessarily, I don't disagree that the rules are not intended to create additional costs. I'm trying to figure out where would the rules where could they create additional costs that are not in the statutes?
So this harks back to what I was kind of suggesting at the very beginning of this RAC process, which is that we not do a whole lot of rules around public meetings law, including defining and redefining terms that have been litigated for decades. But we're doing that, which is fine. I understand why we're doing a lot of these rules, but I suspect there potentially could be costs associated with litigating or otherwise trying to implement OGEC's interpretation of what the law currently is. I think there's always a risk of expense when essentially we're codifying case law and the attorney general opinions. And I think there's a chance that we might have gotten some of these things a little bit off, and there could be potentially a cost. And that in my suggested words, essentially would essentially leave room for that potential fiscal impact that may or may not hit. So that's my logic.
Okay, I understand. Anyone else with any comments or suggestions? All right, I'm going to need the 13 members of the RAC that were appointed by the commission last week before, lost track, to vote on this. But obviously you need to know whether I'm going to adopt Rob's proposed language. And I probably need about a 5-minute break. So let's come back at 3:15 and I will let you know. All right. Thank you. Okay. Okay, we're back. So, ran that by my counsel, and we will stick with the do not create. And the reasoning, Rob, is that the fiscal impact statement has to be a fiscal impact of the rule, not of other consequences like litigation. And so you would need to be able to show that this particular rule as it's written would have a cost, as opposed to the statute having the cost. I mean, I understand that there may be some fiscal impacts if the rules get challenged, but that isn't what we're being asked to say in terms of cost of compliance. Go ahead.
I'll just note for the record, I'll be voting no for that reason. I believe I've given two discrete examples of where these rules actually do increase costs in local government. A former client in particular, because I disagree with your reading of the Attorney General's opinion, the Attorney General's manual. I also believe it will increase costs of conducting executive sessions if we want to have any member appear virtually by way of the rule we talked about earlier today, more than just the theoretical ones related to expansion of definitions and things like that. But I understand totally where you're coming from. Don't mean to create any more time. I'll just be voting no for those reasons.
Okay. Any other comments? All right. So for now, we're going to ask the committee to vote whether to recommend the fiscal impact statement, and Casey will do a roll call.
Susan, I have a
And this-
question real quick about this process. This is Gabe. This is my first rack. Do we need a motion before we vote on anything, or is it on the table?
I believe it is on the table. I mean, if someone wishes to make a motion, that's fine.
It's just, this is my job to make sure we do it right. So that's my,
So I understand. Well, let me pull up the purple book. Find it. I don't believe it said that a motion was required. It simply said that the RAC would have to recommend to the governing body, to the commission. So
all right. Well, okay.
I have a question.
go ahead.
Underneath the Administrative Procedures Act, as well as the latest Supreme Court decision dealing with the Chevron deference, and to be safe versus sorry, I think that it would probably be appropriate to make a motion to recommend. Just to
And
cover
that's-
bases, I'm sorry.
That's it. That is fine. So if one of the 13 members appointed by the commission would like to make a motion,
This is Gabe Shepard. I move that we adopt the document as written.
easy.
Ready?
All right.
All right, so if you can please indicate your vote verbally. All right, Beth Woodard.
For the reasons Rob articulated, I'll vote no. I would accept the changes that Rob proposed. But if we're going with as written, it's a no.
Gabe Shepard.
Aye.
Brenda Sanchez.
Yes.
Jeb Bladine.
Yes, with the reservations, which I think will be evident to the commission in the discussion.
Corey Tate,
Yes.
Matthew Call,
Yes.
Rob Bovett,
No, for the reasons I put on the record.
Scott Winkles,
No.
Courtney Sneed,
No.
that is 4 noes and 5 yeses.
Okay. Think about something for a second. I All right, hold on a minute. I'll be right Okay, thank you all for your patience with me. So we will add in some clarification on Rob's objections, just so that they are preserved for the record. And a majority of the quorum, the vote was 4 to 5, so 5 votes carries. We will forward the fiscal impact statement with the addition of the notes of Rob's objections to the commission. And I thank this particular RAC for their participation in the process. And so with that, I will once again end the Rules Advisory Committee process. I thank you all very much. As I said in the beginning, as hard a process as this was, and it was hard for me as well as I'm sure not all that fun for you to give up all your Mondays, but I don't know why my camera keeps going off, but anyway, my appreciation to all of you, and thank you for giving me your time for the past couple months. All right, thank you all. Joe, did you have something final to add?
Is there going to be one final follow-up meeting, or is it just going to go?
There won't be another RAC meeting. It'll go to a final review, and then we will publish the notice. Oh, that's what I was going to specify. We will do the published notice rulemaking, but there will be a fairly lengthy public comment period, and there will be a public hearing before the commission.
Thank you.
And we are finalizing the date for that right now. And so written public comment will be accepted, as well as verbal public comment for those who wish to appear at the public hearing. And so the public notice should be published in the bulletin. So that would be this coming Thursday.
And will press be allowed to record? Sorry.
That's okay.
Susan,
All right.
appreciate all the staff's efforts and your hard work on this, really do.
No, and I may follow up with you, Rob, just to make sure that I adequately incorporate sort of the language of your objections, because I do think that the notice needs to incorporate those and let those go to the commission.
You bet. Happy to help if you need.
Okay. All right, thank you. All right, I'll let you all go, and thank you again.
Thank you, Susan and staff and all who participated.
Thanks, Chip.
Thank you.
And
Bye.
congrats again. And to Les as well.